This particular month, the Electoral Commission went ahead to obviously nullify the nomination of Matthias Walukagga, the National Unit Platform flag bearer for Busiro East. And he went ahead and obviously took his case to court. And on Friday, I think we got the first court hearing, and they all went ahead of submit in what the judge had called in for them. And guess what happened? They told them that on Monday the verdict will be out and it will be sent via their emails. Now, court upholds Electoral Commission's decision to disqualify Walukagga from the MP race. The High Court in Kampala has dismissed petition filed by Busiro East parliamentary aspirant Matthias Walukagga, upholding the Electoral Commission's decision to cancel his nomination on the grounds that he lacked the minimum academic qualifications at the time of nomination. In a judgment delivered on December 21st, 2025, Justice Simon Peter Chinobe ruled that Mr. Walukagga's mature age aptitude test certificate, which he presented for nomination, had expired before the nomination date and could not lawfully support his candidacy for parliamentary seat. Mr. Walukagga had been nominated on October 23rd, 2025 to contest for the position of the Member of Parliament for Busiro constituency in Wakiso district. The seat is currently occupied by seasoned lawyer and politician Medad Segona. Mr. Walukagga's nomination was later challenged by a registered voter, John Rubawak Chilimiro, who petitioned the Electoral Commission, alleging that the Chengera Town Council mayor did not possess the requisite academic qualifications to contest for MP seat. The challenge was heard by the Electoral Commission in November 2025. In a decision communicated on November 25th, the Commission found that Walukagga's mature age aptitude test certificate issued by the Islamic University in Uganda, IUIU, on June 12, 2023, had expired on June 12, 2025, 4 months before nomination. The Commission consequently cancelled his nomination. Mr. Walukagga petitioned the High Court, arguing that the Electoral Commission had acted illegally and without jurisdiction. He contended that his mature age certificate had been equated to advanced level standard by the National Council for Higher Education on June 11, 2025, and this equivalency was sufficient proof of qualification under the law. He further relied on a letter from IUIU dated November 11th, 2025, which stated that a mature age certificate valid if it is used to enroll for further studies. The musician turned politician told court that he enrolled at Central University in August 2023 and was pursuing a bachelor's degree in public administration, arguing that his certificate therefore remained valid. However, the Electoral Commission maintained that the law strictly limits the validity of mature certificate entry to 2 years from the date of issuance. The Commission argued that by the time Walukagga presented his papers for nomination, the certificate had expired and could not form the basis for meeting the constitutional and statutory requirements for parliamentary candidates. Justice Chinobe agreed with the Electoral Commission and second respondent. In his argument, the judge held that while the National Council of Higher Education is mandated to equate academic qualifications, the Electoral Commission has constitutional and statutory authority to determine whether a candidate meets the qualifications for nomination at the time of nomination. Now, Chinobe stated that the question before the Electoral Commission was whether the academic credentials presented by the petitioner were valid for purpose of nomination. The discussion revolved around the expiry of the same. The court examined the timeline of events and found that Mr. Walukagga's certificate expired on June 12th, while the nomination took place on October 23rd, 2025. From the above timeline, I note that the petitioner's only qualification had expired by nomination date, rendering both the certificate and National Council of Higher Education equivalency invalid. Justice Chinobe further held that a letter from IU could not override the clear provisions of the law. On the question of jurisdiction, the court rejected Walukagga's argument that the complaint should not have been entertained by the Electoral Commission. Justice Chinube cited that Article 16(1)(f) of the Constitution, noting that it empowers the Commission to hear and determine election complaints arising before and during poll. The court also dismissed preliminary objections challenging the validity of the Commission's decision and the competency of the appeal, finding that the petition was properly before the court. In the final orders, the High Court dismissed Walukagga's appeal and upheld the decision to cancel his nomination. However, the court declined to award costs to the respondents, noting that the matter raised issues of public importance. The decision brings to close the illegal challenge arising from Walukagga's disqualification from the Busiro East parliamentary race ahead of the 2026 general elections in there. So that's what we've gone ahead to get from Daily Monitor, as they've gone ahead to give us what we call a vast explanation of courts upholding the decision of the Electoral Commission, and Walukagga has been knocked out. And today we are waiting to see whether we will get more people to come up and obviously tell us something about it, especially from the National Unit Platform, as Robert Kyagulanyi Ssentamu, the presidential flag bearer for the National Unit Platform, goes ahead to continue his campaign trail in what we call, right? In what we call the campaign trail in March India East and March India West. So your reaction to this are welcome in the comment section below. I've gone ahead to see people say Chinube is biased because Alex Waisamo from Biro went ahead to roast him live on TV. So will they go to the constitutional courts? We wait for Council Nalukola and Alaka to see what they'll obviously come up with. We out.